Okay, we are live. Okay, hey everyone, welcome to Legalbytes. I'm Alyte, I'm a lawyer, and on this channel we explain the law one bite at a time. So if you're familiar with our channel, you might know that we just hit over 3,000 subscribers and we're so excited. So because of that, I kind of wanted to try out a little bit of a new format. I've done live streams before. I've had one with on this channel, particularly with Nate the Lawyer and Uncivil Law, but I've never done one solo. And I wanted to try one out that's a little bit different than the pre-recorded versions of the videos that we've had before. So let me know if you guys are enjoying this or if you prefer to see our more pre-recorded sort of streamlined sort of videos. But anyway, with that, I wanted to make this video talking about a lawsuit that was filed against Apple recently. So the article was, there was an article that came out here with the Hollywood Reporter here. So they came out with an article talking about an order that came out by the court in a case that was filed against, like I said, it was filed against Apple. It's a class action case filed over Apple's use of employment of the buy button for, hey, the reality of Hannah. Hi. Welcome. Happy to have you here. So anyway, so like I was saying, the lawsuit against Apple is alleging that by using the word buy for these buttons to purchase some version of movies or TV shows off of the iTunes store, people Apple is misleading consumers because of the fact that those products, those movies, TV shows, etc., those can end up disappearing from the Apple's or the iTunes store. And so you're not exactly buying them. So this brings up some really interesting questions about what exactly it is that you're buying when you're buying these products. What exactly does it mean to have digital ownership of, music, TV shows, games, etc. And it also brings up the question of what are reasonable consumer expectations when it comes to these kinds of digital products. Anyway, so with that, let's talk about, actually, before we get into the order itself, I wanted to go over how Apple has actually kind of dealt with this sort of issue before. So let me see if I can remove this and share. Let's see here. Hold for just 1 minute here. Okay. This one right here. Okay, so why App Store apps are now labeled get instead of free. So this was back in 2014. I'm not sure if you remember, but the iOS App Store and the Google Play Store both used to label certain applications that you could download. You didn't necessarily have to pay upfront for those apps, that they used to be labeled as free. But there was an issue because a lot of parents were noticing that their kids were running up their credit cards with thousands of dollars worth of purchases that they weren't exactly expecting. So there was, particularly in Europe, regulators were putting a lot of pressure on Apple and Google over this label, this get label that you can see right there in the photo. So that's why they ended up changing that label from free to get, because it wasn't necessarily technically free if they had certain purchases after you purchase after you download the app itself. So what's interesting to me here is that I think that this case is going to be a little bit similar to that sort of situation that happened back in 2014 when Apple and Google both changed those labels. Okay. And so let's go now to the actual order here. Okay, if I can pull that up. Okay, so we have here the order granting in part and denying in part. And I think I'm going to make my face go away so you guys can see just that. Okay, so we have here the order on a motion to dismiss. So what happened was the so David Andino here filed a class action complaint against Apple. Apple filed a motion to dismiss, and now this order is by the judge is determining whether or not the complaint can be dismissed. So spoiler alert, it was mostly, the motion to dismiss was mostly denied, meaning that there was just basically one or two parts of the complaint that the judge dismissed, and the rest of it is going to move forward with a lawsuit. So, okay, so let's get into first kind of these factual allegations here, and then we'll kind of talk a little bit about sort of what a motion to dismiss is and what it needs and what Apple was claiming and kind of what the judge ended up deciding. So what we have here is Apple Inc. defendant is one of the world's largest computer and phone manufacturers and retailers. Apple's iTunes application allows consumers to rent or buy movies, television shows, music, and other content. If the consumer desires to rent a movie, Apple advertises that for a fee of around $5.99, the consumer will have access to the movie for 30 days and then for 48 hours after the consumer first starts to watch it. For a higher fee of around $19.99, Apple offers consumers the option to buy the content. When a consumer opts to buy the content, it then appears in their purchased folder. David Andino argues this labeling is deceptive, as the use of a buy button and representation that content has been purchased leads consumers to believe their access cannot be revoked. Plaintiff alleges this is untrue, as Apple reserves the right to terminate the consumer's access and use of content at any time, and in fact has done so on numerous occasions. Plaintiff claims he would not have purchased the content or would not have paid as much if he had known that his access and use could be terminated at any time. Accordingly, plaintiff filed a class action complaint on behalf of himself and those similarly situated for violations of, first, California's Consumer Legal Remedies Act, or CLRA, second, California's False Advertising Law, or FAL, and third, California's Unfair Competition Law. After the complaint was amended to add a fourth claim for unjust enrichment, Apple brought this motion to dismiss. So, okay, so that's basically the heart of it, the gist of this lawsuit. And now we'll go into this, basically four main issues that Apple seems to have had with the complaint here. And so we'll kind of go into those and talk first, actually, before we get into that, what I want to talk about is what sort of needs to be argued in order for a motion to dismiss to be successful here. So basically, a motion to dismiss, what it is it's hey, Manny Fabani, thank you. And thank you. Joel was justified in The Last of Us Part 2. Hashtag original fan. Thank you. And who is this? Hydrosphere 13, a literal David versus Goliath lawsuit. That is absolutely true. That's a very good point. So for a motion to dismiss to be successful, basically, let's start with what it is first. A motion to dismiss is the first stage that a defendant has to be able to try to make a lawsuit go away. And basically what it means is that the defendant is arguing that the plaintiff has not alleged enough facts in their complaint in order for there to be a plausible in order for them to have for their claim to be plausible, for there to be either the law has to be the law that they've cited that they give me just 1 second. Let me actually go right back to the motion to dismiss here for the legal standard here, because that is the best way to do this. Okay, so a complaint has to contain sufficient factual matter accepted as true to state a claim for relief that is plausible on its face. So basically, you have to have enough facts in order to facts that are applied to the law, so that you show that basically they have the ability to state a claim that's basically plausible. Their allegations are plausible, essentially. So anyway, so the first of the four sort of issues that Apple seems to have here with the complaint is under Article 3 of the Constitution, and that's standing. And that's basically that the Article 3 states that federal courts have jurisdiction over only cases and controversies. So if a case is moot, for example, the courts don't have the ability to try a case that is already basically resolved because the issue has just sort of resolved itself. That would be mootness. At the same time, if there's been no injury to the plaintiff, they have a potential injury or they're concerned about getting an injury, that is something that a court really can't hear. So there has to be an actual injury. So in this case, what Apple argued was that plaintiff, let's see, let me go back to this page here. So the plaintiff argued, or excuse me, let me get here. Okay, so Apple argued here that the plaintiff's alleged injury, which it describes as the possibility that the purchased content may one day disappear, is not concrete, but rather speculative. So they're saying that because the plaintiff just has this concern, this worry that all of this content that they've purchased, all of these movies in their iTunes library are going to go away, that therefore they haven't yet been injured. But the court disagreed with that. So they said that this, however, as plaintiff points out, misconstrues the injury. Plaintiff responds that his injury is not that he may one day lose access to his content. Rather, the injury plaintiff asserts is that he spent money purchasing the content and that he wouldn't have otherwise, the content that he wouldn't have otherwise that he wouldn't have otherwise purchased as a result of Apple's misrepresentation. So this occurred at the time of purchase. So basically the injury is not in possibly the content going away, but the injury was in the purchase itself, that they were misled during the purchase, or so they say. That's the argument, right? So, okay. So moving on here. So in this case, you can already see in this order here that the judge is kind of cutting away from Apple here. It looks like they're agreeing more with the plaintiff. So let's see if that continues as we go on. So they say here, in a false advertising case, plaintiffs. Okay, let me go back for just a second here first. Sorry. So to establish standing, so in order to have standing, like I said, there has to be a case or controversy. Plaintiff needs to allege an economic injury in fact. So basically there needs to be some sort of economic harm here, right? So when it comes to a false advertising case like this one, plaintiffs meet this requirement if they show that by relying on a misrepresentation on a product label, they paid more for a product than they otherwise would have paid, or they bought it when they otherwise would not have done so. So it sounds like from the beginning of this order, from the judge's sort of recounting of the allegations, it sounds like that was something that the plaintiff did allege here, right? He said that he had purchased a bunch of stuff off the iTunes store. He didn't realize that it was going to go away at some point, and he would not have purchased it if he had known that that was going to happen. So, okay, let's see. Okay, so, I mean, that's pretty much all we really need to know as far as this issue is concerned. I mean, that basically is it, right? Because the court already said that the injury isn't so much in the product being taken off the iTunes store, but it's in the original purchase. So, but they do go on to cite law saying that where a consumer knows or believes the same representations were false in the past, a consumer's, let me see here, a consumer's, sorry, give me 1 second. A consumer's inability to rely on a misrepresentation on a package is an ongoing injury. So even if they've known that this kind of stuff has been happening in the past, the fact that the consumer can't rely on a certain label going forward is a continued injury going forward as well. So that's the first issue. That's basically it there. So it looks like from this point, the court is going to, okay. Hey, Stephen, even good to see you here. Hello, Uncivil Law. Thank you. Very much. Thank you for the super chat as well. Yes, getting him. Okay, so all right. Moving forward, so that was the first issue. So you can see here that the court is already kind of cutting away from Apple, like I said. So let's see what the other three issues say, though, because the judge can end up dismissing one part of a complaint but not other parts. So another issue that another issue that Apple had here with this particular complaint, with this kind of allegation, right, was the fact that they said that for the allegation of fraud, plaintiff needs to state with particularity of what actually constitutes fraud. Like, what exactly did they do that was constituting fraud? So in a false advertising case, the court said here, let me pull to this part of the order. Okay. So the court said that, in a false advertising case, this means identifying specific advertisements and promotional materials here. So, here, okay, let me see here. Line 18. So specifically, here plaintiff has identified specific promotional materials according to the court. The court said specifically, he alleges that consumers are given the option to buy digital content in a variety of ways via a smartphone, computer, or tablet, through iTunes app, or on Apple TV. So he says also that so plaintiff has also explained how such materials are false or misleading, as he notes that reasonable consumers expect buying the content means access cannot be revoked. So basically, essentially, okay, so what he's saying here is that the actual fraud here that he's alleging is in the fact that the buy button, it says buy. People generally think that buy means that you can actually have it forever, right? You buy a book, you take the book home, you can do whatever you want with it, essentially, barring some limitations. You can't make a copy of it, but you can do pretty much almost anything else that you would want to do with that book. So, generally speaking, people have that sort of expectations when they're buying even digital content, according to the plaintiff. And then he says that, however, he explains how this is untrue, as Apple reserves the right to terminate the consumer's access and use at any time. So that's basically where he says that Stephen, even, he says, this is certainly my definition of buying. I think that that's the case for probably a lot of people. So, and yeah, this is your previous comments. They don't get to keep the thing that they're buying. So exactly, right. Okay. So let's see here. So basically the argument that they haven't really said where the allegation of fraud is, the court says, nope. Here it is, it's right here. So most likely, it looks like the court is going to agree with the plaintiff on this issue as well. So moving on to the third issue that Apple had with this complaint. Let's see, is the page 11. Actually, not on page 11. Sorry. Give me 1 second here. Okay, reasonable consumer. So they were trying to say, so Apple tries to say here that the plaintiff fails to state a claim because he mischaracterizes the buy and purchase language and views it in an unreasonable manner. They try to say that, here is it. Where is it here where it says it? Okay, give me just 1 second here. Unfortunately, I should have said this, that my plugin for highlighting documents on web pages is not working. So that is one of the reasons why this is not as direct as I would want it to be. But bear with me for a second. So, okay, so Apple argues here that the plaintiff has failed to state a claim because he mischaracterizes the buy and purchase language and views it in an unreasonable manner. Apple contends that no reasonable consumer would believe that purchased content would remain on the iTunes platform indefinitely. But in common language, the court says, the term buy means to acquire possession over something. It seems plausible, at least at the motion to dismiss stage, that reasonable consumers would expect their access wouldn't be revoked. So, but this is an interesting point, however, that Apple says is that, I mean, can we really expect from now until 3,000 years from now that iTunes will continue to exist and we'll still be able to watch the programs that we've ostensibly purchased? You know, I don't know that people really have that kind of expectation, but you know, the idea that that iTunes can revoke it at some point in time of their own accord is something that I think that a lot of people would probably be surprised about. Let me know if you agree or disagree. So hello, Declan. Good to see you here. Sadly, in the digital age, you don't really own the product you buy. You just get a license to use it. And that's exactly true here. So that's precisely what we're talking about with the iTunes store is we're talking about products that we're not exactly buying, but we're licensing. And I think that actually is something that is part of the issue here, right? Because we're talking about, you know, items that we've licensed for a certain use, and we can't do the same sort of things that we can if we were to purchase like a physical copy, for example. So, and part of that is because there's something in copyright and trademarks, but more salient to this conversation in copyright is the first sale doctrine. So when you purchase a movie or a book or a CD or any sort of a physical copy of a thing, what you have is you have a right of first sale. So in other words, after the person who owns the copyright, after they've made their first sale on that item, they have no more control over that item after the physical item, I should say, after that point. So you can do whatever you want with a physical book or with a DVD or with a CD after you've purchased it, after you've paid good money for it. You can give it away. That's why we can give it away to a library. You can resell it. You can put it in your will and give it to your family at the time of your death. But once we've moved to having all of our movies and TV shows and all this kind of stuff on platforms like iTunes, now all of these are operating off of licenses. We're not exactly fully buying them like we would be if we were buying a CD or a DVD or some other sort of physical copy of these things. So that's a really good point that you make here. So, okay, so with the issue of the reasonable consumer, basically the court ends up saying that no, you know, at the motion to dismiss stage, it's at least plausible that reasonable consumers would expect their access wouldn't be revoked. So what they're talking about at the, you know, what they're saying here is at least at the motion to dismiss stage. And that's because so as a litigation goes on, there are several different stages at which the defense can try to make this lawsuit go away. The first one, like I said, is in a motion to dismiss. And basically, the court has to basically assume that all of the facts that are alleged in the complaint are true. The court just looks at those body of facts. They're not looking at, you know, if there maybe exist some other facts that would make a certain claim less likely to be true, more likely to be true. They're just looking at the complaint. It doesn't matter if the defendant says, well, I have this counter argument. It doesn't matter. That's all they're looking at is the facts, and do they assert enough to state a claim? So after a motion to dismiss, if a defendant is unsuccessful, then they can go to a motion for summary judgment stage. So that's after a motion to dismiss is denied. Then they go into discovery. They exchange all kinds of information. They do depositions. They have documents go back and forth. And then the defense can, and the the plaintiff side also can do this, but usually we think of the defense doing this because they're the ones trying to make a case go away as quickly as possible, usually. So they can file what's called a motion for summary judgment, basically saying that, all of the facts on the table here, no reasonable jury could find in the favor of the opposite side. No, if it's the defense, no reasonable jury could find on the side of the plaintiff. So, in this particular case, where she's talking, or she or he, actually, I don't know if the judge is a man or a woman, where the judge says that, at least at a motion to dismiss stage, assuming that all of the facts as alleged are true, that, reasonable consumers would expect that their access couldn't be revoked. So essentially this is stating a claim, but that does suggest that there's a possibility that at the motion for summary judgment stage, where they're actually looking at the full body of evidence, that there's a possibility that a defendant could win in this case. So it says further here, Apple also argues that because a user can download purchased content for full and irrevocable access, the buy and purchase language is accurate. But the court cannot consider such factual contentions at the motion to dismiss stage. So like I just said, right, the argument about the facts, looking at the full body of the facts, saying that that no reasonable jury could find on the other side, that's an argument for the motion for summary judgment stage. So while it does look like the judge is also siding with the plaintiff on this particular issue, for this one, it looks like maybe it could go to a summary judgment. Okay, so moving on here. So then we have Apple's last claim here. And that is not their last claim, but their last issue here is on the plaintiff's request for equitable restitution claims. So I'll talk about this one just really quickly because it's pretty dry. The plaintiff basically just he alleged that Apple was unjustly enriched through this whole process. And unjust enrichment basically just means that the plaintiff alleges that the defendant acted wrongly, and as a result, they secured some sort of a windfall for themselves, and that was unjust as a result. So basically, in order for a plaintiff to make an allegation for that kind of a claim, they have to basically not have any sort of remedy under any other claim. So in this case, because the plaintiff is alleging all of these other claims under the what are these? Under the CLRA, the UCL, and the FAL, there are remedies under all of those statutes, right? Under those California statutes. So the judge basically says you can't also allege this one because you have the ability to get a remedy under those. So basically, that was the one issue where the judge sided away from the plaintiff and for Apple. So essentially what this means is that the case can go forward, but it doesn't. Oh, here's another question. Hamza Ali, I wonder if EU has dealt with a similar issue. Seems to ring a bell. So that is actually, I'm not sure if you saw earlier, but what I mentioned was there was an issue that was kind of similar that Apple and Google dealt with, which was on their Apple, on the iOS Play Store and the Google iOS App Store and the Google Play Store, where apps that you could download without having to pay a fee up front, they used to be labeled free, but now they're labeled get. That was the whole reason for that, right? Was because European regulators were starting to really put a lot of pressure on Apple and Google over that sort of labeling, saying that it wasn't straightforward, that it was actually pretty misleading because there were a bunch of people who were finding that it was mostly parents with their kids were finding that their kids were running up huge bills on their credit cards through these apps because there were in-app purchases. So that may be why it rings a bell. But I don't know if the EU is also looking at this particular issue as well or not. But great comment, thank you. So basically, okay. So generally speaking, I personally think that this is kind of a good case against Apple. I think that one point that I mentioned about the motion for summary judgment, that Apple has a counterfact that that people can actually download content that they've purchased through the iTunes store, that they can download that and play it indefinitely. I think that is potentially a counter argument that that Apple could use, maybe possibly successfully, but that definitely is a question in this case. But I mean, aside from that, I mean, I don't know if that's enough to satisfy the meaning of buy as it suggests, because, you know, there's still a possible counter argument to that that could basically say that people have an expectation of using a certain product, you know, on the iTunes store. You know, they want to be able to use it in the way that they have downloaded it, so to speak. So rather than, you know, having just I guess downloading it and then using it indefinitely. I don't know if a lot of people actually know about that. But anyway, so you know, is that enough to satisfy the meaning of buy as it suggests, or not? Personally, I think that's an important question, and it could be decided on a motion for summary judgment. But most likely, though, I think that this case is probably most likely to settle because after a hurdle like this one, a motion to dismiss, you know, Apple, of course, is going to try to make a case like this go away as early as possible. But now that the case is moving forward and the court has kind of really kept pretty much all of these claims really in this case, it looks like it's still a relatively strong case against Apple moving into a lawsuit. So it would be interesting to see if it actually settles or if it continues to move forward towards trial. Most of these cases actually do settle. So those are my thoughts, but what do you guys think? Let us know in the comments below, and let us know also if you guys enjoyed this live stream. I know it's a little bit rough. There's more airtime. I'm not exactly as streamlined or straightforward as I normally am in my pre-recorded videos. I have the benefit of editing all of that airtime out. So, but anyway, let us know in the comments below all your thoughts on this case on the live stream. Yeah, otherwise, if you enjoyed this, please do hit the like button. It does help us. And please do subscribe to the channel if you haven't already. It really does help us grow. Like I said, we just hit 3,000 subscribers, and would love to hit even more. So anyway, oh, great. Thanks, Hamza. Live stream seemed like a cool way, similar to shorts reacting to current events. So, all right, thank you. And I will see you guys in the next video. Bye.